It's going to be the same outcome either way.
All right, everyone, we're going to get started. All right, ladies and gentlemen, thank you for joining us this afternoon. I am Joseph Tex Dozier. I'm the president of the University of Republicans. If you'd like to come to some of our meetings, I would greatly encourage law school students to come. We meet Mondays at 7 in the Bartlett Trophy Lounge. To get on our list host, please go to list.uchicago.edu. Just sign up for Republicans. We've got a great range of events we do throughout the year. We don't spam your inbox. Upcoming, we'll have a trip to a gun range if you're interested in coming with us. It's exercise Second Amendment rights, and then we're also going to be...
Is this before or after McDonald comes down?
We're doing it before, and then we'll have a celebratory, hopefully after. And then also at the end of May, we're working on a free to choose, free to booze event in honor of Milton Friedman. So definitely got some great events coming up. Today, we got great people debating, is Obamacare constitutional? On March 21st, H.R. 3590 was passed, which has become known as Obamacare. Immediately after, 14 states' attorney generals filed injunctions that it is unconstitutional. And the debate has waged on. Pundits have been going back and forth. So we thought, why don't we do a UChicago style debate with a graduate of the law school, Shapiro, Cato Institute scholar, and Professor David Strauss.
Well, thank you very much for having me. This originated because Tex, who's actually a former Cato intern, saw my video challenge that I would debate anyone, anytime, anywhere on the constitutionality of Obamacare. This resulted out of, well, our new media guys and their great gimmicks to send this thing viral. But about a month ago, there was a so-called debate or panel on the constitutionality of Obamacare at the University of Washington Law School in Seattle. And apparently they couldn't find anybody to take the position that I'm now taking. So I thought this was ridiculous, and I wrote a little blog post on Cato's blog saying, well, off the top of my head, here's 6 scholars. And if they're too busy and too senior, well, I'm willing to do that. So here I am, and this is the, I think the third of, gosh, about 15 that I'm scheduled for thus far, this and in future months, so we'll see what happens. It's certainly an honor and a privilege to be here with my former professor. This, of course, means that if I misstate the law in any way, you can certainly blame him. Cato actually has a close tie with the law school. My boss, Roger Pilon, got his doctorate here at the university. Richard Epstein is a senior fellow, and indeed I had the privilege of editing one of his briefs for us in the CLS versus Martinez case recently. He's also going to be writing an article for my Supreme Court review on that case. Eric Posner also was kind enough to write for the first volume that I edited on the Boumediene case. It was a best article in that volume and easiest to edit as well. My predecessor also was a University of Chicago Law School grad, Mark Moeller. One of Cato's VPs, Gene Healy, is the University of Chicago Law School grad. So there's a close connection, and I'm happy to be here and further that, and keep the fires burning. Now, as Tex said, the original suit had 14 states, Virginia separately, and then 13 states joining the Florida suit. There have now been an additional at least 6 states joining those suits. 5 of those, I think that's up to 5 of those 21, have Democratic attorneys general. So it's certainly a bipartisan challenge to this thing. And these are serious lawsuits, as are some of the ones by individuals. Individuals, of course, are also challenging the health care reform, with serious lawyers behind them. It's really difficult to predict how it'll come out in the courts because this new law is unprecedented, quite literally without precedent in the scope of its regulatory scope and its expansion of federal power. The strongest legal argument attacks the individual mandate, that every man, woman, and child has to buy a particular good or service. This is unprecedented. Never before has the federal government said that people face a civil penalty for declining to participate in the marketplace. And never before have courts had to consider such a breathtaking assertion of raw power under the Commerce Clause. Not even during the New Deal with the Wickard versus Filburn case, which, for the benefit of the college students, involved a farmer growing crops in his backyard and the court saying that Congress could regulate that clear interstate commerce activity. Other constitutional issues relate to the 10th Amendment. Those I think I'll go into briefly. I think those are less serious or less, won't have a lesser success of winning, and the Congress's taxing power. Now, I'm heartened that so many of you have come out to listen to these constitutional issues. Perhaps not surprising because you're in law school after all, but for example, the Speaker of the House, Nancy Pelosi, when asked about what she thought about the constitutional issues that have been raised, said, "Are you serious?" As if it was a real argument to raise the Constitution when you're discussing something that's so important. It's like, constitutional arguments have become, well, when you've run out of real policy arguments, then you might invoke this dead letter from the 18th century. Or Congressman Phil Crane from right here in Illinois, right? That famous video that when he was asked where is the justification for Congress to do this, he said, well, I don't care. What I'm concerned about is that the little kids get health care coverage. It's the I have the Cato Constitution. Maybe the ACS Constitution is different, but I can't find the little kids getting health care exception to the Constitution here. Okay, so as I said, the strongest criticism is the individual mandate, that it exceeds Congress's power to, quote, regulate commerce among the several states. In 1942, as I said, in Wickard versus Philbin, the Supreme Court for the first time upheld the federal regulation of local economic activity. For our first 150 years, this just would have been anathema and clearly unconstitutional. The court employed a similar analysis 5 years ago in Gonzalez versus Raich, when it held that the production of marijuana for personal use was an economic activity that Congress could regulate. So basically, the state of the law is that the commerce power extends to channels of interstate commerce, instrumentalities of interstate commerce, and economic activities that substantially affect interstate commerce. Now, while the court has rejected nearly all challenges under the Commerce Clause since the New Deal, 2 lawsuits have been successful. I'm talking, of course, of Lopez and Morrison. In Lopez, the court struck down a law prohibiting the possession of guns near schools, saying that this law was not, quote, part of a larger regulation of economic activity in which the regulatory scheme could be undercut unless the intrastate activity were regulated. In seeking to distinguish between what is truly national and what is truly local, the court limited the reach of the commerce power to exclude activity that's not directly economic in nature. Similarly, the court struck down the Violence Against Women Act in Morrison because the gender-motivated violence regulated had only a, quote, attenuated economic effect. So these cases demonstrate that there are some limits, thankfully, to Congress's Commerce Clause power. As Justice Kennedy explained in his Lopez concurrence, were the federal government to take over the regulation of entire areas of traditional state concern, the boundaries between the spheres of federal and state authority would blur and political responsibility would become illusory. This precedent, taken at face value, suggests that courts should find the individual mandate unconstitutional, because to do otherwise would expand the Commerce Clause to regulate economic inactivity, and indeed non-economic inactivity that's wholly local, something the court has never done. I think to ratify this assertion of power to invoke to pass the individual mandate, the court would have to go beyond Raich and Wickard and everything further. Now, to be sure, there are situations in which the government can force individuals to engage in a transaction or activity. If you run a hotel or a restaurant, you have to serve all comers. If you run a train, same thing. But nobody has to operate a hotel or a restaurant or purchase lodging or food, and individuals aren't commercial enterprises. Other people might raise the draft or the Selective Service Act. You have to register. Well, that actually is tied to an actual enumerated power, the Congress's power to raise armies.